Good afternoon. Welcome on in to this episode of From Day One. This afternoon, we have a good friend, Taco Mike, with us, and we're going to start at a hearing with a judge who laughs at a sovereign citizen. Let's begin, shall we? Mikey, if you would please, bring it away.
70598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
Thank you, Ms. Strickland. That would be you, Kevin.
Yes, sir.
Kevin Hurst.
Okay, where are we on this trial, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr.
we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection.
I learned you're fucked up.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
You fucked up, sir.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
You truly owe the debt.
Just indicate that we did attach to those.
They already
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have
Yes,
this.
please, Your Honor.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Kevin,
Hurst.
the only answer you
I don't
should say
understand anything.
no.
Okay,
that's,
fine.
I don't even understand
that's not
why
the right
I'm
answer.
here.
I'm going to mute
I don't
you.
even understand what's going
Please,
on.
Your Honor,
I'm
mute
muting
his
Mr.
ass.
Hurst.
Thank
and I
you.
will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst
Oh,
to speak.
you don't
Ms.
have
Strickard, you're
to.
responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Now let's let the
Okay,
idiot.
so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt.
And they tried to. You said that you didn't want a contract and return to sender. Man, sometimes it's better when I just let the audio go, but Dude, this guy's probably gonna, rile me up. Back to the moron Kevin. I believe his name is Hurst.
Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of his debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me.
Denied.
And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again.
Please, Your Honor.
Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery.
Yes.
That allows you to serve written discovery. That allows her to serve written discovery.
Yes.
And she did so. If you elect not to receive it, then that's on
Then
you.
you're an
That's the
idiot.
risk, and you bear the risk of that. But I would urge you, and let me tell you,
I
as I
urge you
told
not
at
to
the
be an
beginning,
idiot.
you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences.
Yes, he does, Your Honor.
I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences
No,
of
he
the
definitely
choices that
doesn't.
you are making. However, as I indicated, you have an absolute constitutional right to
To be
represent
stupid.
yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules will cut against you, then so be
So
it.
be
I
it.
got a question. They are claiming that this debt belonged to me, but they have to produce all the proof and verify that this debt belongs to me.
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt.
Oh, dear freaking whatever deity you believe in. I'm trying as much as I can to censor myself here. She told you she sent it in the packet. You decided to write your NCC 1701 all rights reserved bull crap on. So you would have had it had you not been a soft-sit moron. But no, you're not going to listen to that. Go ahead and continue. I said
That
continue.
belongs to me, right?
She has the burden of proof.
Okay. Thank you.
I don't know what you think
All
is
right.
concerned.
I'm sorry, Ms. Rickards?
Go ahead.
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package.
Yeah, because
Because
she
if
technically
you
doesn't
do
have
not,
to.
the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you
really
I got a question. Do you
Oh dear
should
God.
they have received should they have sent me something before they sending me this package since the last court date
No.
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No,
No,
you're
you
going to do what you
moron.
choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again.
for me.
We had this
Mute him, Your
conversation
Honor.
before, didn't
Sorry,
we? We
Go
had
ahead.
this conversation before.
go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time.
And
You will
only
either accept the
one more
package
time.
or you will not. You will answer and serve the request for admissions in accordance with the Michigan court rules, or you will not.
Please
And
don't.
then if you do not, then those things will be deemed to be conclusively admitted.
Yeah, that.
If you choose to send written request for discovery, you have a right to do that too. You can send written in
You're not
writing
smart
terms,
enough
request for
to, but
production of documents, and request for admissions. Same as her.
so let's move on to the
All right, we
second
are on the
hearing of
record.
this idiot.
This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good
Pre-trial.
morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Moron,
Kevin Hurst.
All
also
right.
known as the moron.
I do hereby reserve all of my rights, claiming none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
Good,
right.
then shut up.
All right, where are we on this file?
Yes.
Judge,
thanks for the go.
discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay,
Like tomorrow.
let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
This is where you do get to speak, sir.
It looks like this.
What's that?
It looks like this.
Yeah, I'm asking
Okay, yeah.
if you received the motion for summary disposition filed by the plaintiff.
There's
Do
the
I have
paper
it?
to say you're a
Yes, sir.
fucking moron if
Yes.
she wins.
Okay, so let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July
Thank
26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer, or
I give him credit for not at least making
Yes, Mikey.
up some schedule conflict, because you know his soft sit schedule is absolutely open.
to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
By the
All
way,
right,
hearing
the
number
court has
3.
had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant.
Uh-huh.
Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. And number 7,
Okay.
does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too.
The judge is having fun here.
Also note for the record that
Yes, Your
having
Honor.
reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant.
AKA
May not
loser.
rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the
Oh, the irony of a sovereign citizen getting hit by not having an affidavit.
Yes.
defendant is somewhat obtuse. I quote,
Somewhat.
for example, from the third page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again,
Go ahead,
plaintiff
Your Honor.
claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there.
Uh-huh.
Yes, Your Honor.
So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the
Moron.
plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
There's the
Oh,
7-day
that
rules,
was fun.
but they're required to be
That
able to
was
sign.
fun.
Yes, Mikey, that was awesome. I will give you credit for that one. Good one. Now, I'm assuming you got us another one, Mikey?
All right. Now we gotta do this.
Yes, Mikey. Yes, we do. Give it to us. Get it, Mikey? Give it to us, baby. Okay. I think we're just a few seconds from having that set up.
This is Eddie Banks. He is old school.
This is the Banks, Eddie Banks L matter.
Oh my God, we
He's
actually
been
have an
crazy
Eddie
for
Banks?
years.
Wow.
We haven't
I
heard
thought he
from
fell
him.
off the earth.
Banks L, you want to come forward?
You really wish to engage me?
Yes, I do. You come grab a seat, or you want me to stand up? Come so you're closer to the mic.
No. See, this is a
Yes.
arena of honorable men.
No, you're not
So-
honorable.
If y'all can run y'all court the way you wish, allow me the same respect,
No.
and everything is copacetic.
This is the Eddie Banks
Whoa, stop. I highly doubt you even know what copacetic means.
Eddie Banks L matter 380-55-485. This was on, there was previously a competency
This gets worse.
evaluation ordered. There was some non-compliance with that, but ultimately, most